case briefs, and so much more. LSData's got what you're looking for.
In the 1971 Vermont Supreme Court case Coolidge v. Coolidge, the court dealt with a dispute between a 77-year-old plaintiff and her son, the defendant, over jointly owned property. The property had been jointly owned by the plaintiff, her husband, and their son at one time, with the intention that full ownership would eventually go to the surviving member once the others passed away. The plaintiff's husband died, and she eventually moved away from the property, seeking to divide it. The defendant opposed the partition, arguing that the survivor was meant to be the ultimate owner of the entire property. The case centered on the legal rule that co-owners of property have the right to request division of that property unless a clear agreement against such division exists. Despite the defendant's appeal of the trial court's order to partition the property, the Vermont Supreme Court affirmed the judgment and remanded the case for further partition proceedings. In denying the defendant's motion to re-argue, the court dismissed several arguments, including inconsistencies in the court's interpretation of evidence and the claim that the statute governing partition, 12 VSA Section 5161, was unconstitutional. Ultimately, the court upheld the trial court's decision and factored in the defendant's financial contribution to the property during its evaluation.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.